I'm Robert Sparks, a divorce attorney out of Tampa, Florida. I'm talking about how the length of the marriage impacts alimony in the state of Florida. Remember back in 2023, huge sweeping bill came in and revised Florida's statutes, the laws, as it pertains to alimony in the state of Florida. Particularly, we're going to only talk about how the length of the marriage impacts alimony now. Florida lays out 3 different subcategories when it talks about duration. 1, short-term marriages. Number 2, moderates. And number 3, long-term. Where you fall in this designation of duration of the marriage dictates and will heavily impact A, either the alimony you can receive, or B, if you're defending against a spouse's alimony claim. So diving into short-term. Short-term alimony, the statute provides, those are marriages that are less than 10 years. And why is that important? It says if you're married for less than 10 years, the max amount of the duration, how long you're going to have to pay alimony, is 50% of the marriage. All right, example, you're married 5 years, 50% of that marriage is 2.5. Does that mean you're automatically going to pay 2.5 years of alimony? No. The idea that is the max. The statute talks about the max that one spouse can get. So when you're looking at short term, you want to think, okay, what is this good for? Well, this is good for short-term marriages where maybe you don't have children, and it helps limit the scope to say, hey, are you really going to seek alimony on a 2-year marriage? Are you really going to seek alimony on a 5-year marriage if we're in about reasonable incomes? In my opinion, where does the statute hurt? It hurts new moms. Why? Because even in less than a 10-year marriage, it's typically where new marriages begin to have children. So envision yourself of a 4-year-old and a 2-year-old. You've been married, let's say 8 years. This statute's going to say you can do no better in court than 4 years. Well, 4 years of alimony doesn't get you very far when you have a 4 and 2-year-old. It's very easy to say, oh, well, mom, you can go straight back to work. But keep in mind, work is impacted by daycare. It's a negative return, but ultimately, this statute's going to say, at the end of the day, no more alimony past that 4-year mark. It can be very devastating in those cases. Moderate term marriages, okay, now we're outside the 10-year mark. If you've been married somewhere between 10 and 20 years, the statute defines your marriage as moderate. And what that means is under the statute, alimony for no more than 60% of the marriage. Same factor. I'm married, Rob, right at the 10-year mark. What's the best I can do in alimony? 60% or 6 years. Where this is good and bad depends on that big duration. As you start creeping towards that 20-year mark, you start saying, okay, 20 years, 60% is only 12. 12 years of alimony. Why is that good? Why is that bad? Well, state of Florida said no such thing anymore of permanent alimony. If you're the paying spouse, the bad news is you are going to pay, but your duration's going to be capped. The law was trying to design to allow you to move on to another life without having permanent alimony. When I started practicing family law, permanent alimony awards were being handed out pursuant to the case law at 10 years. So think about that. Young couple marries, they have 2 children early. Let's say you're only 32, you've been married 10 years, permanent alimony, meaning alimony that you're going to pay for life unless your spouse remarries. That scenario is exactly why this law was created, why alimony reform and bans on alimony began in the state of Florida. So in this situation, 60% for a moderate duration marriage, which means moderate term, 10 to 20 years. All right, the third form when we're looking at durational alimony is what's considered long-term. Long-term is now defined by marriages that are 20 years or more. And that's important because your alimony factor means that you're entitled to 75% of the marriage. You have a client that comes in and said, I've been married for 19 years and 6 months. Good lawyers are going to say, wait another 6 months. Why? Because you're moving from that 60% threshold all the way up to 75% of the duration of the marriage. You still cannot in the state of Florida get permanent alimony, but when you get into a duration of 75% of 30, 75% of 25 years, that long duration feels permanent. And why? Because no matter what, even on a permanent basis, Florida really spelled out as well the payor, i.e. the person paying the alimony's ability to terminate. When you're in these long-term marriages of 30 plus years, you're looking at retirement coming, you're going to hit that Social Security age anyway. So the lawyers try to work out how to make it fair to say, okay, we know that somebody should not have to work till they die to pay alimony. Florida cured that in the statute. So even though the alimony factor may say, hey, 15, 20 years of alimony, if you have an older spouse that's looking at retirement, you may not actually get those full 15 years. But at the end of the day, The big takeaway when duration matters is because it dictates the max amount. It's broken down into 3 categories: your short-term marriages, your moderate marriages, and your long-term marriages. I would stress, when you're just looking at the percentages, remember that it's your worst day in court. And one thing that we've learned, nobody walks into a settlement and says, today, I'll take my worst day. At the same time in a settlement, nobody walks in and says, I'm only gonna settle if I get my best day. The idea is the statute tried to give the lawyers the framework to start putting those alimony cases so that we can be better informed to our clients. We can give them the risk and exposure so they can make the best decisions to take ownership of the case and work towards a compromise and a settlement.